Hello, everyone, and welcome to this afternoon's webinar, where we are going to be looking at global trademarking for e-commerce, how to protect, expand, and dominate the global markets while expanding and growing your brand. When it comes to the topic, we're joined today by Mo from Trademark Brothers, who will be going through very shortly about a few different areas of trademarking, what you need to be aware of, what you can do moving forward. And before we go into that, I'm just going to briefly explain, how we're going to be running things today. So just to give you a bit of background, my name's Liam. I'm from Simply VAT, and I'm the Business Development and Partnerships Manager. We are looking at today, obviously, as mentioned, that trademarking aspect. There will be some Q&A time towards the end of today's session. Anything that we don't get around to answering, Mo or someone from the team, I'm sure will be in touch after. And then, without further ado, I'll pass you straight over to Mo, who will be starting off today.
Thanks, Liam. Thanks for the introduction, and lovely to be here with Simply VAT. And thanks for giving us the platform to talk to many of your clients and those that have used you in the past and hopefully present. So, who are we, Trademark Brothers? So, we're a company based in the UK. Typically, we basically provide a service that is registered. We register trademarks. We register trademarks for companies all over the world, predominantly startups, SMEs, and entrepreneurs. That's our main target audience, and we manage and protect trademarks. Like I said, in the UK, EU, US, those are the three main territories that a lot of our clients go for. And then after that, we can help and assist file trademarks anywhere in the world. Not only do we do trademark registration services, but we also do, as you can see on the slides, we do trademark application reviews. So sometimes we get some clients that are looking to self-file but need an extra hand. So we just give it a quick review. We handle trademark oppositions pretty much all over the world. We assist with social media handle acquisition at times. So at times you can claim social media handles on the back of a trademark registration. We also do trademarking for Amazon brand registry, specifically for that. And then we also advise on different intellectual property rights, such as design rights registrations or copyright, or if you're looking to assign trademarks or intellectual property from one entity to another, we can also assist with that. So what is intellectual property? So our brand is Trademark Brothers. That's what the company name is called. But trademarks are only one type of intellectual property, and intellectual property basically refers to the creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So a lot of the time when you think about intellectual property, there are something called registered rights and unregistered rights. Registered rights are typically rights that sit on a register somewhere where someone could go and refer to that registered right and look at whether, one person has the rights to use X, Y, or Z. And unregistered rights are that you don't actually get a certificate to say that you're the registered rights owner, but it's an inherent right given to the author of the works. So I'll just go through some of the intellectual property rights really quickly. You have patents, which are mainly around sort of innovations where you've got a very novel innovation that you can protect. Typically, patents are seen in the life sciences, engineering, and computer software sectors. And we don't deal with those, but we have partners that work with us that deal with those. Trade secrets and confidential information, what is known as, are typically unregistered rights, and they are found in employment contracts or potentially also in supplier contracts where you provide a piece of information that you believe is a trade secret or confidential information to your company, and therefore you bind the person that is privy to that information in basically keeping that confidential and not passing that on to any third party. So to give you an example of what trade secret is very quickly, supposedly the recipe for KFC's fried chicken is still somewhere in a crypt in Kentucky, and only a certain amount of people have the original recipe, and only they are privy to it. So, and then also KFC probably in their employment contracts for all of their employees have some sort of clause to say that they're not able to disclose whatever the proportions are of whatever the ingredients they're using to make their chicken. So yeah, trademarks is a registered right. That's what we deal mainly in. Trademarks is all about protecting your brand rights. So what that means is protecting your actual main brand name, your logo, any slogans, any product names, any colors that you may have used and are really inherent to your brand. So yeah, a whole plethora of different things can be protected via trademarks. Design rights are specifically for any novel designs. For design rights, just so you're aware, you ideally have to register those prior to them being in the public domain. And then for copyright, that's an unregistered right. It's given to the author inherently as soon as you put a scribble on a piece of paper. And then geographical indications are mainly to do with things like champagne. So you can only call champagne if it comes from that particular region of France. So yeah, I think we go to the next slide. So what is the importance of IP or intellectual property protection in e-commerce? E-commerce is such a vast area now that a lot of people are basically selling their products on e-commerce platforms. Even services are being sold on e-commerce platforms, and the amount of e-commerce platforms that now exist are far and wide, much more beyond just Amazon. And our view is basically you need to safeguard your competitive edge. Whatever makes you unique, ideally you should be protecting that prior to even selling any goods or services on any e-commerce platform where it's going to be exposed to a large amount of sort of consumers or even your competitors. IP also helps you prevent financial loss. So what we mean by that is once your intellectual property is protected, you can then enforce it. You can let your e-commerce platforms know about any infringement, and they could take action against the person that's infringing on your IP. And then also the last one is all about enhancing customer trust and the goodwill that you've built in your brand. In essence, you want to make sure that you protect that goodwill because you've taken so much time building that, so that no customers are either confused or they know that every time they're buying that product, it comes from an origin that they've already bought from, and they know exactly what they're getting every time they buy from you. So in terms of trademarks, just going into a bit more detail, like I said, a trademark basically distinguishes goods or services of one company or undertaking or trader from another, and trademarks are registered for specific goods or services, which are known as, in the trade, they're known as classifications or categories. And there are 45 classifications that exist, and they are split between goods and services. So classes 1 to 34 are dedicated to goods, and classes 35 to 45 are dedicated to services. And depending on what it is that you guys do through your brand, you may need a mix of both classifications that relate to goods and or services. And in terms of what you can actually trademark, I mentioned this earlier, you can trademark words in sort of no particular format and plain format, as if you're typing to Microsoft Word. That is known as a word mark. That is the ideal situation to be in, because then you own that word or those words in their entirety in any format they would appear in. You can trademark sounds. Those are quite far and few between, but you can trademark sounds. You can trademark colors as well. Again, far and few between, quite difficult to do. And then you can also trademark specific logos. The one thing I will say is you may also want to consider trademarking specific product names or slogans. So to give you an example, Nike have a plethora of trademarks. They would obviously have the word mark for Nike in no particular stylization or format whatsoever. So they own that word in its entirety for the classifications that relate to what it is that they do as a brand. Then they would have Just Do It trademarked as a slogan, because everyone knows that. And so they have an interest in making sure that's protected. And then they would also protect things like Mercurial or Vapor for names of football boots, or Jordan Air, or specific sub-products as well. So in terms of platform tools for IP protection, I mentioned this earlier about why IP is so important for e-commerce. The other reason why it's really important is because if you don't have intellectual property, and if you don't have any intellectual property to show any of these sort of platforms that exist, it might be difficult for you to try and take down a person that's either impersonating your brand or impersonating potentially a product that you've created that's very unique to you. And a lot of platforms nowadays are taking intellectual property really seriously. So Amazon Brand Registry kind of pioneered the way for people to create their own shop front. to show that they are a badge of origin for that particular brand. And brand registry exists, so you are able to create your whole sort of shop front and, on Amazon. Other platforms also have ways of creating your own shop front, or telling them that you're the bona fide owner of that particular brand, and or going through particular forms to fill out, who infringement claims, basically. So we've put on the slides, which platforms have some sort of IP infringement or some sort of registration or verification process that exists for IP that you might have, that you may want to refer to later on. So just a really quick case study, trademarks and disputes within sort of e-commerce. There's been multiple, but one of the ones we've just focused on for this webinar is New Balance and a company called Shishi Changing Trading Co. Limited. So basically, the premise of it was that New Balance successfully sued the online merchant for selling counterfeit shoes on an e-commerce platform like Taobao, which is Chinese-based e-commerce platform, and then also JD.com. And the court basically found that both marketplace platforms were jointly liable for the trademark infringement due to their failure to adequately prevent the sale of counterfeit goods. So it's not just about the person that's actually providing the counterfeit goods, but also the e-commerce platforms have an interest in making sure that they are taking action against any counterfeit goods, because they could also be embroiled in proceedings. So yeah. Here's another one. It's the same one, basically, just to say that the importance of this case and many other cases is that it serves as a reminder for people like yourselves that are running their business through e-commerce platforms to take proactive measures to protect any intellectual property, including trademarks, because that's mainly the one that is focused on for e-commerce platforms. So to make sure that they are able to enforce their own policies against those that are selling counterfeit goods that infringe your rights. So in terms of strategizing your trademark, your trademark strategy internally, the first stage is what we always say to our clients is think about the brand name that you're going for, do a search on that brand name to make sure that there are no trademarks that exist that are similar or identical to what you want to go for, and for similar goods and or services that exist on the trademark register. We've had loads of instances where someone's had a trademark in a particular territory. They now want to come over to the United Kingdom. So they're a US company. They now want to come to the UK and register their brand in the UK. Someone has unfortunately registered that brand already, so they may now have to rebrand or potentially try and broker some sort of coexistence agreement, and then it just kind of gets messy. So try and do a search of the trademark register in the territories that you may wish to basically protect your brand in. What we would typically provide our clients with is if they came to us and asked us to do a search, we would then provide them a risk report, and we would indicate the risk level that brand name would have if they wanted to go ahead with it. And then in terms of the next stage, it's all about planning what the next steps are. So think about where your brand is going, where you think you're going to be selling lots of your, let's say, products or services, and trying to think about in which territories you may want to protect your brand in. It's important for me to say at this stage that trademarks are territorial. So you basically applying and registering your trademark in the US does not mean you have a inherent right to a trademark in the United Kingdom. You only have protected rights in the US. If you want to expand your protection to a different territory, you would have to file in that particular territory. So in terms of the next stage, after you've done the first sort of preliminary fact-finding stage, it's all about getting your trademark, that you found your perfect brand name, and then it's all about drafting the trademark application accurately so it reflects what it is that your business does today and how it's going to diversify in the next 2 to 3 years. So for our clients, it's all about really getting under the skin of where the business is going. So if you're selling toys today, but you're going to potentially be selling milkshakes tomorrow, and you know that's going to be happening, ideally in the drafting stage, we want to try and include as many goods and services that brand will encompass, not just today, but to future-proof it. And so we would do that in the drafting stage. We'd draft it accurately to make sure that we've got as much detail in there as possible. And then once you've sort of looked through it, we would then typically file that trademark application with whichever office it is that you've decided that you want to protect your brand in. and then basically an examiner will pick up that trademark application and begin the examination process. In terms of after the examination process, what I will quickly say is that your trademark gets published onto the trademark register for a period of time. Once that period of time has elapsed, you either get a registered trademark and then it's registered for a period of 10 years, or you may potentially get an opposition by a third party that has a trademark that's potentially similar or identical to what you want to go for, and for similar, identical, or complementary or linked goods and services. If you get an opposition, I'm not going to talk about it on this webinar because it's quite nitty-gritty. If you do get an opposition, though, it can be quite financially sort of cumbersome, and also from a time perspective, it takes quite a long time to come out of an opposition proceeding. We typically would tell our clients to try and broker some sort of amicable agreement with the other side where possible, but if that's not possible, then we would advise the sort of necessary steps, or what steps you could potentially take in that situation if you find yourself in that. In terms of if the trademark does go through and registers, all we say is that the main points to remember are you continue to have to maintain your trademark. So once the trademark is registered, the only thing that you have to really think about is any other trademarks that might be filed that could infringe your trademark rights. Think about also renewal. So set a reminder for 10 years time, because trademarks are valid for 10 years. So every 10 years you have to then renew it for a period of 10 years. Some countries do have some different sort of rules. So in the US, on the 5-year anniversary, on the 5th-year anniversary, you have to show the US Patent and Trademark Office that you're still using your trademark. And if you're not using it, then basically you could potentially lose it. And then the last thing that we always mention is, think beyond the borders of where you're currently trading. It's very easy in an e-commerce world to be able to, your product may sell a couple of times in the country where you're based, but you may find that your product sells much better in a different country entirely. And therefore, we always say, try and think about, if you think you're getting a couple of sales and that could really work well for you, then try and sort of factor that in so you can file a trademark as soon as possible, because trademark registration is not overnight. It can take anywhere, depending on which country it is, it can take from 3 months in the UK to potentially up to 18 to 24 months in the US, up to 4 years in Canada. So really think about where the business is going, where the brand is going. So not to kind of scare anybody, but what does losing control of your brand sort of look like? Well, typically what we would say is that registering your trademark is really important from the beginning, because why would you build a business on quicksand or not solid foundations? It's like building a house. You don't build it from the roof down, you build it from the foundations upwards. And that's the same for any business in our view. So our view is that, competitors could claim your brand name potentially and take that sort of away from you. And then that could hinder your potential for going into new markets, or could confuse consumers. It is true that typically you can rely on something called common law rights. So if you can prove that you've been trading longer than they have, even though they've got a registered trademark, you could cancel their registration, or you could basically challenge it. The one thing with that is that it becomes very difficult to prove. And so that's why we always recommend actually registering a trademark, because then you just have your certificate, your trademark number, and you say, hey, I own this, and cease and desist basically. The other thing is that, like I just mentioned or alluded to, legal disputes can place a burden on your own business resources. You don't want to spend time on people in your organization dealing with legal issues. You rather probably have them spend time on marketing and sales. And then hiring people like us also costs money. So if you don't do something that is potentially less money at the beginning, like protecting the trademark, it could end up costing a lot more later down the line. And then that could also lead to potentially rebranding, which could disrupt sales. It could disrupt SEO, all of your pay-per-click campaigns. A rebrand is ideally not what anyone wants. No business owner wants that, because it just disrupts everything, and it costs a lot of money to plunge money into SEO and marketing once again. And then the last thing is that, to build the amount of trust that you've had with your consumers for a long time under a particular brand, it may take years to build that all up again under a different brand. So it's just worth investing in the trademarking process from the beginning. I don't say that from a self-importance perspective, but more just from a business perspective. So yeah.
Perfect. Well, thank you so much for that, Mo. That was actually really interesting, and I learned a lot. I'm sure everyone else has also learned a lot about trademarks. I think when you hear the word trademark, obviously, it's quite an important piece, but you don't, I guess, realize how important it is until you really look into it. And especially that New Balance kind of, case study you did there. That was really interesting because I did not know about that at all.
Yeah, no, it's. I was just going to say on that point, we always tell our clients to try and be proactive rather than reactive, and unfortunately, with trademarks, a lot of the time it's quite reactive because you don't really appreciate how important it is until it kind of bites you in the backside. So yeah.
Yeah, definitely. Well, on that as well, obviously now we're just going to jump into a quick Q&A session, and I think tying nicely onto what you've just said there, I guess if we start with the big picture, we've just got a few questions with looking at it as a whole. Why are trademarks not just a legal formality, but they are a key part of that long-term brand strategy in the e-commerce sector? And I guess on the back of that as well, just to tie it in with another one we have here, how can a trademark become a strategic asset? What is it that makes it so important, I guess, for that growth?
Yeah, so from our perspective, the whole idea of a trademark is predominantly to preserve the goodwill that you're going to be building in that brand. A lot of businesses nowadays, from a startup SME and entrepreneur perspective, they have like competing priorities, and a lot of people will say, "Well, I need to sell my product so then I can get money to do X, Y, Z." Well, our view is that investing in trademarking is actually investing in the bigger picture because, like I said, you're building on solid foundations. You know that your brand's not going to be taken away from you because you've already protected it. Not only that, you want to try and deter competitors from using your brand, and if they do try and use your brand, that can hinder the progress of the business quite substantially. The only other point I will make is that what may start off as like a very small seed in the e-commerce platform perspective can turn into quite a big venture, and people don't realize that. Some people just go with the trend of swapping and changing products, but a lot of the time, what we've noticed now is that people are actually trying to build brands, or either sub brands or main brands that actually have longevity. And with those brands, a lot of the time they attract investors. So what we've done, or what we've noticed now, is that a lot of our clients, whether they're selling like ice baths because that's the newest trend, they are actually gaining a lot of traction with investors. And a lot of the time with investors, they also want some sort of protection over the brand, because unfortunately that is the only valuable part of that business. There's only a finite amount of ways you can make chocolate or an ice bath or whatever it might be, but it's the brand that pushes it. And if you don't have any protection over that, then in reality you've not really got much else there. So yeah.
I think you mentioned something really important there as well about the sub brands, because that was going to lead me on to another question that I had. So when you're building multiple product lines or sub brands under that one company, what's the smartest kind of trademark strategy to avoid that? Any potential overlap with the brands, any confusion, and
Yeah.
does it need to be, done straight away? I guess, yeah. What would that look like if you have any kind of experience with that?
Yeah, the way that we advise our clients most of the time is, if you know that you've got a new sub product coming out and you're going to call it something really wacky and you think that's quite an interesting name, then we always say, like, before rolling it out, try and start the trademarking process sooner rather than later. At least have the trademark lodged so that you can go out into the marketplace and use that brand name, knowing that, yes, it's not registered, but at least it's been lodged, and therefore it's going through the process. And we typically would say, get in touch with us, or at least file your trademark for that particular sub brand name or product name or whatever it might be a couple of months before you start rolling it out into the public domain. Typically, if you look at any large company, it doesn't have to be a large company, but that's just their strategy. Apple would never release a product without having filed the trademarks in pretty much all over the world before they've actually launched a product. And the same should go for any company in reality, where if they feel that there is a lot of goodwill in that potential product name or that sub product, then they should probably try and start the process as quickly as possible. The one thing I didn't mention, and that is quite interesting, is if the brand name that you're going for, the product name, is descriptive of what it is that you're selling, in reality, you can't actually protect that. So the only way that you can protect a trademark is that you can only protect the trademark if it's distinctive of the goods and services that you provide as a business. And what I mean by that is, just very quickly, if I had an orange juice brand and I called my orange juice brand 100% Fresh Squeeze orange juice, and I wanted to protect it for orange juice, I wouldn't be able to do that because it would just monopolize that term and nobody else would be able to use it. And therefore, anything that's descriptive is basically rejected by any intellectual property office across the world. And that's just like a blanket rule. But anything that's distinctive, like Liam's or Mo's 100% Fresh Squeeze orange juice, that's fine because our names make it distinctive. So a lot of the time we're finding that, people are just like, well, we'll just come up with a descriptive name for our brand or our product. Well, that's good and bad. It's good because you're able to use it, but it's also bad because anybody else is able to use it as well, if that makes sense. And so if you find that somebody else is using it and you're annoyed with that and you want to take action against them, then you're not able to, because actually you've gone for a brand name that's totally descriptive, and therefore you've kind of waived your right or ability to stop them, if that makes sense.
Yeah, I think that's also quite interesting because when you were saying that, I know it's quite random thoughts to probably have, but I was kind of like looking at that product as a whole. And, let's just say we walk into any high street store or, any kind of beauty brand on the high street. There is, let's just go with, I don't know, concealer. How would you protect anything like that for possible? Is it more so like, how they're made, the ingredients? Because obviously there is about hundreds of beauty brands on the UK high streets, and obviously more way out of, across the world. How does a brand protect that kind of, recipe, or, how they're made that product from being stolen and copied, because there's so many different consistencies and shades and all that kind of stuff?
Yeah, well, with a lot of our food and drink clients, they always ask us, like, we've got a particular recipe, like, how do we protect our recipes? The reality is that there's no particular protection over a particular recipe or a formula or a makeup. Yes, you could potentially get a patent on something like a chemical makeup or some sort of pharmaceutical drug that's coming out, because you can protect the molecular formula of that. But in terms of actual ingredients, putting them together, typically, if you think about a chocolate bar, you can't protect a way a chocolate bar is made. It requires certain ingredients to then become a chocolate bar. It requires cocoa. It may be that Cadbury uses 10% of sugar and Lindt uses 50% sugar, but the raw ingredients to make chocolate are all kind of out there and nobody can own those. So that is, again, why the brand is really important, because in my opinion, Cadbury's make substandard chocolate, but it's actually the brand that pushes Cadbury's, if that makes sense. And everybody has this nostalgic feeling every time they pick up a Cadbury's bar. They know exactly what they're getting every time they pick that up, if that makes sense. So yeah,
until you see the price increases on a Friday, as I'm sure we're all aware of that. But no, I think that, that makes a lot of sense. And I mean, when you're looking at it as well, I guess leading into, it ties nicely into one more question I have, really. When you're building that kind of like strategy, when should you really look at the trademarking? I guess it's a case of, same that we advise our clients of like VAT, maybe like as early as possible. But, when I'm doing this branding strategy, when should I get in touch?
Yeah, I think it's difficult because I understand that a lot of business owners have competing priorities, like I mentioned earlier, and some are just like, well, I'm going to buy my stock, and I'm going to do my branding, and my advice always is like, why are you buying packaging? Why are you doing branding? Why are you spending money on marketing, on all of these things that are going to be pushing your brand out into the public domain when you have zero protection on that brand? So you've now spent X amount of money on all those activities, but you don't even own the brand. So for me, it's just doing things back to front, if that makes sense. And so, I would suggest as early as possible. it may be that some people don't want to take that suggestion and they're just happy to ride the wave and then deal with it as and when, and that's
Mhm.
potentially also okay. But it's not as severe, but it's kind of like sleeping with one eye open. If and when someone then infringes it, then okay, well, we're gonna have to deal with it as and when. So yeah.
Perfect. And then I think looking at like markets, because I think obviously when you're growing a brand, as I'm sure we're aware, here at Simply Fact, we deal with people growing their brands all the time. So I know it'd be quite common for our clients, like if they're looking at a new marketplace or a new country, how does owning a trademark help them like expand further? Do they need to be wary in other markets? Are they, when they do their first trademarking check, is it just the local market? Is it all the markets? How would that kind of look like, really?
Yeah, sure. So typically, if we've got a UK client, the three main markets for a UK client typically tend to be the United Kingdom, because that's where they're based. Then happens to be the European Union, because with a European Union trademark, you actually get access or trademark rights in all of the 27 European Union member states. And then typically after the EU, it's then the US, because it's just such a big market, the US. If for whatever reason a client finds that one of the markets, like let's say Switzerland, is a big market for them, then we would tell them, look, factor that into your trademark strategy. You may want to trademark that also quite soon. The good thing with trademarks is more so from a cash flow perspective, is that let's just say we filed a trademark in the UK today, which is, I think it's the 29th of May. If we filed a trademark today in the UK, and let's say you wanted to also file a trademark in the EU, but you just don't have the money for it just yet, and you want to make sure you've got the UK rights, what you can do is you can benefit from something called a priority window. And what that means is that we could file in the EU within a 6-month period or priority window from the date of filing in the UK, and backdate that EU filing to the same date of the UK filing, as long as it's within the 6-month window, if that makes sense. And that sometimes helps startups or smaller businesses sort of balance out their cash flow, but also benefit from the original filing date that they filed their UK one in, if that makes sense. So yeah.
Yeah. I think, yeah, that's perfect. And I mean, when it comes to it as well, when you're kind of, because I think this is all to do with like starting a brand and like, I guess building that trust with customers as well. Because like you've rightly mentioned, if you see, I don't know, I'm someone who has the whole Apple ecosystem. So therefore, that brand has built trust with me.
Yeah.
How important would you say is trademarking in building that trust with the customer, getting returning customers? Have you seen any kind of cases with that? I mean, I think we're all victim to, going back to the brands that we know. Um,
Yeah.
yeah, how would that look like?
Yeah, I mean, from our, like I said right at the beginning, the whole idea of trademarking, the whole idea of brand protection is because you've built a certain level of trust and goodwill amongst your consumers, and
Hmm.
so you want to make sure that you've kind of protected that. Enforce a lot of the time with startups and SMEs and entrepreneurs, it's all about, yes, I've got the trademark, but now I have to enforce it. And it is true that in policing and enforcing your intellectual property rights, it does cost money, and it does, it takes time and resource to kind of monitor and keep on top of it. And it's very difficult to know exactly what's going on everywhere, if that makes sense. And there are tools out there. So we use tools for our clients to be able to monitor different platforms like social media platforms, e-commerce platforms. But the good thing about e-commerce platforms in particular is that actually on one of the slides that I mentioned, a lot of them have their own sort of infringement policies now. So there are forms that you can literally fill out where you basically provide your trademark certificate, you provide them with what you own, you provide them with your listings or ASINs or whatever it might be, and then you take the ASIN that's infringing on your trademark, you file it, and then they will just do like potentially an immediate takedown with a review period for that person to then basically outline whether they agree or don't agree or whatever it might be. But the point is that to enforce trademarks from a legal court perspective, it costs a lot of money. But the e-commerce platforms have created ways in which it is the barrier to entry in terms of enforcing your rights is much lower, where it's almost free if you were to fill out those forms yourself. So yeah.
Perfect. Thank you. And I think I've got a couple more questions, and I think with the next one, we have already briefly touched on it, but I think it's always good to, I guess, just hone in on the points. But is there any, or what are the strategic pros and cons of registering those trademarks in individual countries? Or is it possible to do it in a region,
Yeah.
worldwide, international? What would that look like?
Yeah, so there are ways to. So basically, there is a lot of people say I want to go for a trademark and I want to have a global trademark, and there is no such thing as like a global trademark. So you can't just go to an agency and protect the brand everywhere in the world. We typically would recommend our clients to file directly in country by country. So UK, EU, US in country directly. But there is a mechanism and there is an organization called the World Intellectual Property Organization that exists. And there is a thing called the Madrid Protocol, which exists, where you can use your base trademark registration, but you have to have a base trademark registration. And basically, on the back of that, you can choose which territories you want to expand your protection into. And then the trademark filing gets sent to the World Intellectual Property Organization, which is based in Geneva. And then they will send it out to all of the local trademark offices, which you've ticked in terms of territories that you want to try and protect it in. Now, that is not a global trademark. That is just a way to facilitate trying to get trademark rights in different countries on the back of your home registration. And a lot of the time, it looks kind of easy. It's a bit of a form-filling exercise, but later down the line, it could cost you more because you then need local attorneys, etc., etc. So we typically would suggest for at least like the bigger countries like Australia, New Zealand, the EU, the US, we would just basically file directly for our clients. Any countries that are a bit more obscure, let's just say Madagascar or Russia, I don't know who's doing business in Russia at the moment, but Russia, then yeah, we would suggest going through the Madrid Protocol because that's potentially the easiest route to being able to file in those more obscure countries.
Perfect, thank you. And looking a bit further at the, I guess, the strategic side, everyone's favorite topic, return on investment. If we're looking at the ROI, of the investment in a trademark versus, other brand building efforts, what would, I guess, that look like? Let's just say I'm building a brand, but I'm not going to invest in my trademarking, from the offset, but instead I'm going to focus on influencer marketing, my advertisement. What would, am I risking an ROI? Yeah, how would that look, I guess? Or what would you advise?
Yeah, sure. Yeah, sure. So I kind of already mentioned this.
Mm,
Why would you spend loads of money in marketing, pay per click, SEO, if you don't have any protection on that thing that you're trying to promote, if that makes sense? So the first thing is that with a trademark, yes, you have to pay for it, but you have protection for 10 years. And unfortunately, I don't like to call it this, but it's kind of like an insurance policy for your brand. You've got an insurance policy for the next 10 years for your brand. You typically, with an insurance policy, you have to renew that insurance policy every year. The good thing with it, like I mentioned, with the trademark is that you don't have to do that every year. You just have to do it once, and it's protected for 10 years. So, from my perspective, the ROI is better in trademarking than it is in any other thing, because with marketing, it's a constant effort. You have to pay money, you have to do Google ads, you have to do whatever it might be. So you're constantly plunging money into it. And I could probably guarantee the first 3 months of plunging money into ads and SEO will basically, outstrip the amount of money you're going to spend on a trademark application.
thank you. And I guess I've just got one final question, which is a bit of an obscure one. So, but when it comes to the manufacturing of a product, for example, what role would you having that trademark play in, you know, negotiating with manufacturers, distributors, and especially if they're manufacturing your product, how does that kind of prevent them leaking? Obviously, it's legal protection, but I don't know whether you've ever had a case like that, whether you know of like a famous case. Yeah.
Yeah, so it's not an obscure question at all. It's actually a really relevant question to e-commerce businesses because, fortunately or unfortunately, a lot of e-commerce businesses procure a lot of their goods from China and other countries where, in reality, you may not have the best relationship, or you may not really know what's going on in the background with whoever it is that you're procuring those goods from. And we've had one of our clients in the past that is a clothing company. They have a particular brand. They had a manufacturer that was manufacturing their clothing for them in China. The manufacturer suddenly, from one year to another, said, we're going to increase the manufacturing cost by 30%. And our client basically said, well, that's really detrimental to us, because our margin is this and you're bringing it down to this, and it's just kind of not feasible for us to run on those margins, or the business is basically going to be on its knees. So they said, look, we're going to go to a different manufacturer. And at that point, the manufacturer basically pulled out a trademark registration in China for the brand name that they have. And they basically kind of held them a bit ransom, in the sense that they said, well, you can't go to any other manufacturer and provide them with this brand, because we own the brand rights to this in China. So you either stay with us, or so basically we had to try and get their trademark cancelled, because on the basis of bad faith application. But the point is that a lot of the time you may not know who your manufacturer is. You don't know what their ulterior motive is. And even from a UK perspective, I say this to a lot of food and drink clients, which is, whoever your co-manufacturer is, because you need to start manufacturing that food or drink on scale, you don't know what else they're manufacturing within that factory, if that makes sense. And they may have another line there that's their own line, and they're using your proprietary sort of makeup and ingredients, and then they're just putting a different label on it and selling it. And so in any sort of contract or distribution agreements, or any sort of manufacturing service level agreements, you should have some clauses in there which, like I mentioned about trade secrets and confidential information, that basically try and give you a bit more leverage, where if there were to be an issue, you could rely back on that service level agreement or contract that you have with your manufacturer to say, well, you've agreed to this, which is you're not going to ever file a trademark registration for the brand name that we provide you with. You're never going to do this, or you're never going to do that. And that can have that can be worth its weight in gold at times. So yeah, it's just about doing your due diligence before you just jump into like a venture. Some people are quite sort of happy just to go on trust, but a lot of the time that trust, not to be negative, but that you don't know how far that trust can go. So yeah.
No, I think that's really important. And I think, as you've mentioned quite a few times today, it is all about doing your due diligence, making sure it's everything, because you're investing a lot of money into building this brand, right? So you want to make sure that you're protected, so that you can, tying back to the title today, grow, expand and dominate. So you can really get that kind of growth for your business. But thank you so much for answering all those questions. I feel like that was, really insightful, especially for, us today. And I mean, tying into something we've done together, we have a blog on our website, which you've kindly wrote for us, which will be, honing in on a lot of stuff and touching upon a few things we've discussed today. And then if you have any questions or anything at all, please do feel free to contact Trademark Brothers directly. Mo will be happy to advise, or anyone from the team will be able to kind of advise and help protect your brand, so you don't have any manufacturing situations like we've just had. And yeah, thank you so much for attending today's webinar. I'm sure we will circulate the recording today, and it'll be accessible for anyone who would like to watch it moving forward. And feel free to get in touch. And thank you again, Mo. It's been a pleasure to present this with you. And yeah,
Thanks a lot, Liam. Thanks a lot, guys.
thank you.
Cheers.